How likely is a judge to award the non-custodial parent equal custody or 50-50 custody if after the primary custodial parent has already been the primary custodial parent for 3 years or more? Well, before you hear another word, know this. The answer in these situations is it depends on many and varying factors. Nobody likes that kind of answer, but it's the truth here. What do you do first? Consult several attorneys in your jurisdiction about whether you may have a good case for a change of child custody if you believe you may. Many attorneys who consider themselves or bill themselves as good and knowledgeable attorneys on this subject don't really know, but they won't tell you, so you need to suss that out for yourself by interviewing many. Get second, third, and fourth opinions, but be warned. If an attorney tells you what sounds too good to be true, it likely is too good to be true and is being told to you to part you from your money. Generally speaking, if no circumstances pertaining to the child custody award have changed substantially and materially during that 3-year period since the order was issued, it is highly unlikely that the court would modify the child custody award and award the non-custodial parent custody or even equal custody or joint custody. So, just what is a substantial and material change in circumstances pertaining to the child custody award? I cannot speak to how all jurisdictions define it, but in Utah, where I practice divorce and family law, the substantial and material change in circumstances that will lead to a change in the child custody award is overwhelmingly, but not in all cases, but overwhelmingly, a change for the worse in the custodial parent's circumstances. Even if the non-custodial parent could indisputably prove that he or she has significantly bettered himself or herself as a parent, if the custodial parent has become no worse than he or she was when the custody award was originally made, if his or her circumstances are substantially and materially unchanged, then a modification of custody will not likely be deemed appropriate or in the best interest of the children. But what if a court expressly stated that a parent was not awarded sole or joint custody due to suffering from some defect that, but for the defect, he or she would have been awarded custody or joint custody? And then what if that parent has since remedied that defect? In Utah, that could be a basis for modifying the child custody award. See Hogg v. Hogg, Volume 649, Pacific Reporter 2nd, page 51, from the Supreme Court session in Utah of 1982. If neither parent's circumstances have substantially and materially changed, but the child's circumstances have substantially and materially changed since the original custody award was made, such that it would be in the child's best interest for custody of the child to change, that could be a legitimate basis for seeking to modify the child custody award.